KV Sri Lanka and the Secretary of State for the Home Department.
Before we begin, I should make it clear that the court is making an anonymity order in this case, that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings. I always remind people of this because, of course, we are being live streamed and it's very easy to make mistakes, which is why I do that. But I'm sure, of course, Mr. Drabble, you would not do any such thing.
No.
Yes.
May it please the court, and as your lordships and my lady know, I appear for the appellant, together with my learned friend Roland Toll, Charlotte Bayati and Michelle Brewer. My learned friends Neil Sheldon and Matthew Hill appear for the respondent, Secretary of State, and Stephanie Harrison, Queen's Counsel, and Alan Bandagani appear for the three interveners. My lady, there's one piece of housekeeping. We have handed in some photographs which we may need to be further identified when we come to look at the detail of the evidence. There are several sets of photographs taken at various points, not always now available or in front of the papers. These are photographs, just to be clear, taken by my client's uncle shortly after his arrival in the United Kingdom, i.e. pretty well on arrival.
They were in evidence, were they?
They were in evidence, and we will be looking at what Dr. Arnold, for example, said in the course of giving evidence to the upper tribunal. I am told, and I'm sure it's accurate, that these are the photographs that he was shown, so I was quite keen just to pin that down. So that's the one piece of housekeeping. My lady and my lords will have seen that this is my appeal from the judgment of the Court of Appeal. That court dismissed our appeal from the decision of the upper tribunal, acting as fact finder, in turn dismissing my client's appeal against the Secretary of State's claim for asylum. The central issue in the case concerns the upper tribunal's treatment of the medical evidence and the conclusions that could be properly drawn from that evidence. The facts of the case are highly unusual, and can properly be said to be unique. My client is a Tamil. He arrived in the United Kingdom on the 24th of February 2011 and claimed asylum on the 14th of March 2011. At the time he claimed asylum, he was very heavily scarred. It's common ground that the scars were caused by contact with a heated metal rod. My client has given a consistent account of the circumstances in which he was burnt, and it will be necessary to look at the immediate detail of that account in due course. His claim is that he was burnt in the course of being tortured. His case was supported by medical evidence consisting both of medical reports and oral evidence given to the upper tribunal, and it will be necessary, we submit, to look at the detail of that medical evidence again in due course. The upper tribunal spent considerable effort in exploring the possibility that the burns were caused not by torture, but by voluntarily by a third party in circumstances where the use of anesthesia or something similar was deployed. That form of treatment became known and is known in the literature as self-inflicted by proxy, SIBP. In the event, the upper tribunal held that his claim to be tortured did not withstand scrutiny, and that SIBP was left as the only real possibility as an explanation for the burns. And it is inevitable that we will need to examine the detail of that reasoning. The majority of the Court of Appeal, as the Court will have seen, upheld the upper tribunal. But Lord Justice Elias dissented. I say at once, and unsurprisingly, that we rely on the reasoning of Lord Justice Elias. I think it is fair to say, in essence, agreed with our submissions as to the purport of the medical evidence. I propose to proceed by first of all setting out some bullet points about the background to the case, just highlight points about where we are. Secondly, showing the court photos of the scars and diagrams identifying their location. I've already shown the court the photographs, so look at the diagrams because we need to identify, to understand the detail of the medical evidence, the identification of the particular scars. One of the background evidence that it will be necessary to deal with is a potential difference between the scars on my client's right arm, which the court will see on the first sheet of the photographs, and the scars on his back, which your lordship and my ladies will also see from the later photographs. Next task will be to show the court the basic structure of the upper tribunal decision, and in particular its conclusions on the medical evidence, which was to the effect that my client's account was clinically implausible. Next, going through the medical evidence, if I'm allowed to, in some detail. There are these potential sources of material about the medical evidence, the written reports from the experts themselves, the upper tribunal's own record of the oral evidence, and finally, we have, but the Court of Appeal did not have, transcripts of the evidence available. We've taken the liberty of inserting the transcripts into the supplementary bundle of additional material. We told the Secretary of State that that's what we were going to do, but as I understand it, the Secretary of State either resists the court looking at the transcripts or reserves his position. My position is straightforward, having been told by the Court of Appeal that we couldn't demonstrate our case because we didn't know what the transcript said. For better or for worse, I've taken the view that the court should have available the transcripts, helpful or unhelpful as they are to my case. I actually say they help, but I would take the same line regardless. We have been told that the material in the transcripts has to be considered. So there they are, and I propose to ask permission to look at them when we go through the detail of the medical evidence.
When we get to that point,
Mr.
Mr. Sheldon will tell us what he
indeed
thinks about it at that stage.
Yep. So, can I just, for the first task, is just to recall where we are as a matter of basic fact on these cases. If my ladies and my lords will look at our printed case, MS 799, so that's Core Volume 1, MS 799, Paragraph 2 just sets out 3 basic points about the evidential position. First, the only medical opinion as to the consistency of the scars with the appellant's account was that the scars in the account were either consistent, to use the word used by Professor Lingham, we'll look precisely at what he says, or highly consistent with that account, to use the words used by Zapata Bravo. Second basic point is there's no evidence of any other Sri Lankan acquiring scars which were self-inflicted by proxy. One reservation about that, which I'll have to come to, because there was a first-tier tribunal, which says something that's not easy to decipher, and there was some discussion in the upper tribunal case. But subject to that reservation, no other evidence of any Sri Lankan acquiring scars which were self-inflicted by proxy, let alone on the scale of the burning that the photographs reveal. And third, none of the doctors who gave evidence were of the opinion that the scars were self-inflicted by proxy. But as I've said already, the upper tribunal formed the view that my client's account was clinically implausible, despite the medical evidence which flowed entirely in my client's direction. There was no medical evidence contradicting those opinions. Importantly, when we look at what happened in front of the upper tribunal, the expression of view that the opinions of Dr. Zapata Bravo and Dr. Udili, for example, were clinically implausible was not put to them. The respondent did not take issue with any of the medical evidence, indeed is recorded in the closing submissions as agreeing it in broad terms. As I've already said, there was no evidence of SIBP. There was evidence, on the contrary, of branding detainees with heated metal rods. All of that is necessary to keep in the forefront of one's mind as one comes into the detail of the medical evidence on which the case will inevitably turn. Your Lordships and my ladies and my lords have already seen the pictures of the scars, which is the next of my tasks. I don't think I need to spend any more time on the photographs. It is helpful if the court will look at MS 1388 and 1389, MS 1388 and 1389, so that is in CV2. And we are in the report of Dr. Zapata Bravo. Report looks at, say, 1388. See his name as the examiner at the top of the page. And he's identifying scars which he calls S1 through to S5. On 1388. There's a slight confusion because Dr. Lingham also refers to the scars, but the numbering is slightly different. It's respectfully easier just to stay with Zapata Bravo because he discusses in more detail the difference of what he regards as differences between the scars on the back and the scars on the arm.
We're slightly concerned about any breach of anonymity that might come through the pictures being shown on the broadcast. Now, we've got the pictures, but we could try and make sure that they're not visible to the cameras.
The video, that's fine.
It's all right at the moment.
Well, it is. video when it's live streamed tomorrow, but it's what's happened now. But I'll go and ask them to see what we can do.
Yeah. Well, thank you.
Yes, I have to say I hadn't thought of that.
No. Well, this
well-
being an asylum case,
No, I completely understand the point.
anonymity is standard
No, no, I
practice.
Well, and important. I mean, in this, on our case, important. I'm not trying to do anything else. I hadn't thought about the photos I handed in initially. But if we've seen them, we can put them away effectively, as far as I'm concerned for now.
Yes.
So, I don't think there's any anonymity problem about looking at 1389. One ignores the very top of the page, at least, that they identify S6 and S7, which are the two scars on the arm. Just to stay with 13884 for a moment, there's some discussion in the evidence, I don't think anything really turns on it, about how S1 and S2 may originally have been a single scar, the gap between them being caused by the shape of the back, essentially. Similar point about S3 and S4.
I mean, inflicted by a single pressing.
Yes, that's one potential explanation.
Well, especially 1 and 2, look.
Yes, 1 and 2,
They're
and possibly
definitely
3 and 4.
a continuous line. Yeah.
Yes, exactly. And I mean, I don't imagine the court will get into this, but there's some discussion about the length of time it might have taken to inflict the scars. And obviously, if there were effectively two blows with a heated metal rod, that might take rather less time than separate burns. But
And a third.
and then there's S5, yes, exactly. And then there were the ones on the arm. So we'll see what the detail of that says. Now, if we then go, next task, to the upper tribunal decision, which starts at MS 945, so we're in CV 1. And if the court will just look, first of all, can I just draw to the court's attention paragraph 11 of the upper tribunal decision, MS 951. Which is just the caveat about my point that there was no evidence of a practice of SIBP in Sri Lanka. There is one first tribunal decision as BV, in which the judge mentioned the possibility of SIBP, third line of paragraph 11, but did not make a finding that this had occurred, simply holding that the appellant's case was not proved. We don't know anything more about the detail of the injuries or whatever, about how similar it was to my client's injuries. So if we go on through the tribunal decision, get to MS 967,
So paragraph 11, BV really doesn't take the matter much further.
No.
But there's one unreported case where the tribunal does seem to have found SIBP.
to have mentioned it. I think it's even more removed.
UV.
Oh, UV, sorry, I'm being slow.
So that's it, I think, Mr. Drabble.
Yes. And we know no more, I mean, I know no more, despite having tried to find out,
Very well.
about how truly similar the cases are. I mean, obviously, one of the striking features of my case is the extent of the burns. So they're, as you see from the photograph, pretty extensive. So the tribunal's finding is that my client has volunteered for an obviously pretty unpleasant set of injuries being inflicted on him. Now, 967, as I was saying.
Are you able to give paragraph numbers as well? I'm not working from the same copy.
Sorry.
Just the
Yes.
paragraph number.
No, I understand. I mean, I'm the same as your ladyship, but I've rather assumed that even if we were working off the paper copies, the MS numbers were there, but it's paragraph 82.
Thank you.
It's page 85 of CV1.
Don't worry about that. Just the paragraph
I'll
numbers will be absolutely fine. Thank you.
try to give the paragraph numbers as I go along. Anyway, it's paragraphs 82 to 80. At 967, starting at paragraph 82, the tribunal starts to summarise the expert evidence which it heard or considered. So the witnesses to note on the scarring issue are Professor Lingham, whose written report is summarised in paragraphs 82 through to 86. Look at precisely what he said in due course. He did not give any oral evidence, so the sole material that was available to the tribunal about the consistency of my client's account with the injuries is that recorded in his written report.
May I ask, did he not give oral evidence because he wasn't, nobody asked for cross-examination or what?
Well, I'm being told he wasn't available. What your Lordship's question reminds me to say is that, I think I've already said it actually, but I'll say it again, is that none of the expert evidence are cross-examined in use the word hostile, just in a way which suggested that their medical opinions were wrong by the Home Office or anybody else. We can see precisely what was put to them. There are a lot of questions in which the tribunal plays an active role, but there is no positive case advanced by Mr. Duffy, who is the presenting officer appearing for the Home Office, that the injuries were SIBP. We can see his closing comments, which make just one comment about the medical evidence to suggest that there is a problem about plausibility in one respect. Deal with that. So it's not correct to envisage this as a case in which there was a battle fought out by detailed cross-examination of the experts by the opposing parties. There's a series of questions exploring SIBP from the tribunal and exploring matters such as, can you induce a state of unconsciousness by, for example, an overdose of heroin or controlled overdose of heroin or something of that sort? But it's the tribunals doing all of that. It's not, no one else is making a case to that effect. So that's that's Professor Lingham, 82 to 86. There's Dr. Arnold, whose evidence is recorded at 105 through to 111. court will see that paragraphs 105, yes, well, 105 to 111 summarise the written evidence. And 112 through to 123 summarise his oral evidence. And that summary the summary includes somewhere, and I've lost it, I'll find it again, the proposition that he couldn't tell from the looking at the scars whether or not the injuries were imposed by...
114. Is that the bit you're looking for?
Yes, it's the last sentence of 114. Is what I was thinking of. The whole of 114 is obviously relevant.
He's not saying that about these scars, he's saying it about scars generally.
No,
Because it's looking at scars, and he didn't examine your client.
no, he did look at, well, this is one of the ambiguities that can be picked up on the transcript. He is actually plainly talking about looking at scars. I'll show the court that in due course. But anyway, the oral evidence is summarised for the purpose of present exercise of 112 to 123. I'll come back to it. Barto Bravo is his evidence is summarised in the terms of his written report at paragraphs 124 through to 137. And his oral evidence at 138 through to 148, MS 977 onwards.
One point on 148, Mr. Drabble. Of course, we haven't yet decided whether to allow the transcripts in. If we don't allow the transcripts in, we'll have to do our best with the final sentence in 148. If we do allow the transcripts in, we may in particular want to see whether the reference to the scars would not have been as precise as they were was a reference to all the scars or just the scars on the back.
Yes, we will. Plainly, I presented this in the Court of Appeal without the benefit of the transcripts, rightly or wrongly. Our case was and is that if you read Dr. Zabato Bravo's written report, it's a model of clarity. It plainly is distinguishing between the scars on the back and the scars on the arm. He's saying there is a difference. And the whole of the account of his evidence recorded by the upper tribunal in paragraphs the whole sequence of paragraphs from 138 through to 148, but in particular 146 to 148, are consistent with a distinction between the scars on the back and the scars on the arm, which he stayed with. I mean, if your lordship, for example, just looks at the first sentence of 147,
Well, of course.
first two sentences, he's staying with, my case is, he's staying with the account, which is demonstrated in his written report, that the difference between the scars on the arm and the back, and that is consistent with him being conscious when first burnt on the arms, and then being rendered unconscious by the infliction of the pain.
Well, we'll have to park my point, I think.
Yes, of course.
But of course, Lord Justice Sales does pick up the last sentence of 148
Yes.
with a view to seeking to justify the later amalgamation by the upper tribunal of all the scars.
Yes. Well, our basic point, as your lordship will understand, is that that amalgamation is either simply unsustainable in the light of looking at Zapata Bravo's evidence as a whole, written report, together with his oral evidence, or at the very least inadequately reasoned. It simply doesn't explain why it is the tribunal thinks Zapata Bravo is abandoning his account.
Very well.
When it's made at the 147.
Before we leave 147, are you going to come back to these in detail?
Yes. Well, the short answer is it depends where we go on the transcripts, I think.
Yes. You told us at the outset, that there was some discussion which I hadn't picked up pre-reading, that scars 1, 2, and 3, 4 were each, or as a group, were group results of only 2 impositions of the hot rod rather than 4. It just looks as if Dr. Zavato Bravo isn't taking that on board in 147.
Well, if we do look at the transcripts, it will be necessary to look at precisely what that's the 10-minute point comes in the middle of 147.
I see.
And we'll have to look at the circumstances, if the court's willing to, look at the circumstances in which that was said. The next line of evidence is Adili, which is, and her written evidence is summarised by the tribunal at 149 to 158 at MS 978. And her oral evidence, which is relatively short, is summarised at 159 through to 162, MS 980. And then finally, relevant to the central issue, is the evidence of the written report, rather, from Dr. Alam, which is summarised at 181 through to 183, page 982, 983. She didn't give any oral evidence. The court may have picked up that she wasn't even given any specific material about my client. He was asked, rightly or wrongly, a series of generalised questions, which he answered. Now, the reasoning of the tribunal proceeds first of all by recording the submissions made by the parties, which are at paragraphs 194 through to 221. Already made a submission that there was no positive case advanced by the Home Office to the effect that the injuries were SIBP. And the basic submission that was being made by the Home Office, it can be seen in the middle of paragraph 199.
Page reference, please.
Sorry, MS 987,
Thank you.
CV1, page 105. And your Lordship will see that the Home Office case was that AJ Cameroon made clear that the burden of proof rested on the claimant to show that his scars were caused by torture and that it was not necessary for the decision maker to do more than decide whether that burden had been discharged. If the decision maker concluded it had not been discharged, it was not incumbent on him to prove what he considered the actual cause of the scarring. That would be an unduly speculative enterprise anyway, because such evidence as there was about the practice of SPBP in the context of Sri Lanka was little more than hearsay. And Lordships and ladies can read the remaining submissions made by the Home Office. As relevant. Yes, and as part of those submissions, as Mr. Toll reminds me, paragraph 201 records the Home Office case on what you could tell by looking at the scars. He answers the first question, a clear answer that there was no way of telling the difference between scars inflicted by torturers and scars that were SIBP. It was likely a proxy would try and replicate what was done by torturers, although a proxy might be in a position to achieve more precise scars because the patient would be immobilized. Yes, and 204, his position is recorded as being that in relation to the evidence given by Mr. Rhys-Jones and the medical witnesses, which is what I'm interested in, Mr. Duffy said that he did not in broad terms take issue with any of it. In broad terms, the Home Office would attach significant weight to reports from doctors working for the FFT and the HBF because it was known these organisations had good working practices. And then I shouldn't leave the record of the submissions without drawing attention to paragraph 221, the very last paragraph dealing with the submissions, which record an email sent after the submissions drawing attention to part of Dr. Lamb's answer to the sixth question. And we'll see what the answer was to the sixth question in due course and what can be attached to it. But apart from that email, there is no other submission that goes beyond the submission in 199, which is the burden of proof is on the asylum seeker, and the issue for the tribunal is simply whether it's been discharged. Then if we go to the assessment by the tribunal, we can go to MS 1010, paragraph 320. Between paragraph 320 and 337, or 336, be more precise. The tribunal assess the credibility of my client's basic account of the circumstances in which he says he came to be tortured. And it is obvious the tribunal thought there were difficulties in the account. But paragraph 337, MS 1015, tribunal states we turn to address the medical evidence relating to his scarring, which has informed our overall assessment. If the appellant's scarring was caused by torture in detention, then the possibility of the appellant's account being true, notwithstanding its identified shortcomings, becomes a real one. So the mental exercise carried out by the tribunal is to assess the account, to say it has shortcomings, and then to turn to the medical evidence to see whether that picture changed because of the medical evidence. That approach has its own difficulties. There's a case called Mwanga, which Lord Wilson may recall, in which that sort of compartmentalised approach is criticised. That's not my main complaint about this decision. But nonetheless, it's there. They are not forming a holistic view. They are assessing the inherent credibility and then going on to see, well, does the medical evidence change our minds? Now, if we just look at the detail of this, paragraphs 340 and 341 discuss the categorization applied in accordance with the Istanbul Protocol, to which once again we'll come, to what the tribunal said were consistent or typical of or highly consistent with. We're to deal with that when we look at the actual medical reports, what the witnesses were saying about that. But then
I have a question about that. I hope you don't mind going back briefly to 314. It is on this point, Mr.
Yes, indeed.
Paragraph 314, which is on 1009.
Yep.
The tribunal is addressing itself to the way it should approach the case, and 5 lines down, as noted by Sir Mark Potter in S.A. Somalia, one of the tasks a medical report can be tendered to perform is to corroborate and or lend weight to the account of the asylum seeker by a clear statement as to the consistency of old scars found with the history given.
Yes.
So I think you say, in this regard, the upper tribunal was entirely correct in the self-direction it there gave. Of course, things changed in the Court of Appeal. And speaking for myself, over the weekend, I've been trying to locate in the bundles the skeleton arguments in the Court of Appeal by the Secretary of State and by the interveners, which may have led the majority in the Court of Appeal to take a very different approach.
Yes.
And I don't think those skeleton arguments are in any of our bundles. And I wondered whether it would be too much to ask that we could, at some stage during the case, be provided with their skeleton arguments. And if you or anybody else wants your skeleton argument in too, then fair enough.
Yes. Well, Your Lordship's observation's obviously been heard, and we will address that during the course of the day.
Thank you very much.
Tomorrow. Your Lordship will understand, it is indeed my case that in terms of a direction aimed at the Istanbul Protocol and the domestic case law concerning that, the tribunal got it right in 314.
Quite.
And one of the points of medical reports is that they do corroborate, or can be used, or can corroborate, an account of torture, looking at the matter holistically in accordance with the domestic case law such as Mwanga.
My query relates to the genesis of Lord Justice Sales's narrow view.
I know I have a fairly vivid memory of the course of the argument in the Court of Appeal. I don't recall that issue surfacing as the difference between the parties in the course of the oral argument. I'll be corrected if I'm wrong about that, but I don't. What did occur during the course of the oral argument was some fairly involved discussion about what exactly Zapata Bravo was saying about the scars on the arm as opposed to the scars on the back, with it being put to me in the course of argument by members of the court, particularly Lord Justice Sales, that there was an inconsistency, an internal inconsistency in the report between Dr. Zapata Bravo's treatment of the scars on the back and the scars on the arm, to which my answer was and remains not so, and simply reads the report. And it is totally consistent as to those two matters. Now,
thank you, Mr. Drabble. Where were we?
Good question. Yeah, we were at
337.
Yeah, we were.
Those who distract should recall what they've distracted from.
We were at 340, MS 1016. We were looking in passing effectively at paragraphs 340 and 341. And your lordships and ladies will see that the tribunal say they prefer the evidence given by Dr. Edili and Dr. Zapata Bravo as to the technical circumstances in which the scarring may have come about. Both examine the appellant, and then they say that Professor Lingham's finding was limited to one of mere consistency, and that such a finding does not entail more than a conclusion that torture was among one of the other possible causes. All of that obviously is subject to the criticism effectively made by Lord Justice Elias that if you've got a binary choice between SIBP and torture, that may not be a realistic way of looking at it. But then 342 says all the medical experts agree that there was no inconsistency between the date the appellant said he was subject to burn scarring and the appearance of his scars. They were all agreed as well that from the fact that the scarring on the appellant's back had precise edges and patterning, he would have needed to be unconscious throughout, as otherwise, even with restraint or being held still, his muscles' voluntary reflex would have caused edges to be blurred. Time involved is a relevant factor here. Dr. Zapata Bravo, without contradiction by the other experts, estimated that for the scars to have been inflicted, there must have been several more applications of a heated metal instrument. He considered it that was likely to have taken 10 minutes. Now, we do not accept, as the court will understand from our case, that there was a medical consensus that my client would need to be unconscious throughout. Simply wasn't Dr. Zapata Bravo's evidence, nor was it Dr. Edili's evidence, who's the other witness, who the tribunal has just said in 341 was the evidence that they preferred.
Is that sentence referring just to the back?
Well,
it begins with the back.
It begins with the back. There is no other reasoning in the tribunal, if I can answer your ladyship's question in this way, which deals separately with the arm. So either It's one reason why we put it slightly as a reasons challenge. They're either dealing with everything, saying unconscious throughout, or there's a problem with the upper tribunal's analysis, which is they're not dealing with the possibility that my client was conscious at the beginning of the operation. They just, sequence of events, I mean. The arm falls out. It may be that the tribunal have simply not focusing on the arm when they come to 342, but that doesn't rescue the decision, it does the opposite. That indeed is what...
Well, except that in the next paragraph, they're talking about, it must be recalled, he was first burnt on the arm, and the pain from the burn caused him to fall unconscious.
Yes.
So they haven't forgotten about it by then?
No, but there are two very closely related issues. One is, was it necessary to be unconscious to explain the shape of the scars, particularly on the back, or not? And secondly, was the tribunal's ruling out of the possibility of my client being unconscious for long enough for the scars on the back to be inflicted clinically implausible, which is they need both of them to rescue the decision, if I can put it in that slightly argumentative way. But you've got to have both. You've got to both say you needed to be unconscious when the scars on the back were administered, and Dr. Sabato-Bravos and Dr. Adeli's, we'll come to Adeli in a moment, in due course rather, Dr. Sabato-Bravos and Dr. Adeli's view that he may have become unconscious through pain and stayed that way whilst the scars on the back were imposed is good enough. The tribunal needs both. If I can just, while we're at it, if your ladyship will look at the tribunal, the Court of Appeal. Paragraph 104, page MS 922. He's making a point, and he goes on to make it elsewhere, that you have to deal with the evidence about the shape of the scars on the arm as well as the shape of the scars on the back. I'll come back to that possibly. Now, we were looking at MS 1016, paragraph 342. Having dealt with the shape of the scars in 342, tribunal is then going on to look at the second issue that I've just identified. Would he have remained unconscious for long enough for the scars on the back to be administered? And what they say in the middle of 343, they set out his account, second line of 343, on his account, it's my client's account, it must be recalled, he was first burnt on the upper right arm and the pain from that burn caused him to fall unconscious. If it was clinically likely that someone could be burnt once and then fall unconscious yet not wake up, even when there are more applications of a hot metal instrument, there was nothing to be concerned about. But if on the clinical evidence that scenario was unlikely, then the account was clearly problematic. The issue was addressed by Dr. Zabato Bravo in his oral evidence, and then your lordships and my ladies can see what is said about that. They say halfway down that paragraph, we find it difficult to follow why in the end, he said, the appellant's account of remaining unconscious was plausible. And 344, they summarise the position they've reached on this. At all events, we consider that the medical evidence, as now before is disclosed as a presenting difficulty for the appellant. If his account is correct, and he was given ample opportunity to correct it or qualify it, then he was able to remain unconscious despite several repeated inflictions of the burn scarring, which clinically was an unlikely hypothesis. Lord Justice Lyons held, and I repeat, that the submission which led to that finding, that there was simply no evidential basis for the finding that my client might remain unconscious. The fact that he might remain unconscious was clinically an unlikely hypothesis. We'll see precisely what Dr. Adili says about it, and what Dr. Bravo says about it. Tribunal go on at the foot of the page, or paragraph 345, it's 1017. To discuss the evidence of Dr. Alam. Again, we'll see what is said about that. My submission is it simply does not provide a basis for the finding that he might remain unconscious for long enough for the blows on the back to be administered. It was clinically implausible. It just doesn't answer the question, doesn't address to that. And then 348 contains criticism by the tribunal of Dr. Zabato Bravo's conclusion that the appellant's scarring was highly consistent with his account of having been tortured. They say we do not consider that that is justified when account is taken of the doctor's own evidence indicating, one, it was clinically unlikely, given their precise edging, that his scarring could have been inflicted unless he was unconscious. And two, that it was clinically unlikely a person could remain unconscious throughout multiple applications of hot metal rods to his arms and back, unless he was anaesthetized. Immobilization or restraint short of anesthesia would have recalled his muscle reflexes involuntarily to cause movement. And then that leads into the overall conclusion at 350 on this passage in the evidence, which really addressed to Lord Wilson's questions to me about what the position was being put to the Court of Appeal. But the tribunal say, to summarise, we find that the lack of correlation between the appellant's account of how he was tortured and the resulting nature of the scarring counts against the credibility of that account. So what the tribunal have ended up doing is considering the position in relation to arms and back, held that it was unlikely that he will be scarred with precise edges on arms and back, see 342 and 348, and also unlikely that he would have remained unconscious for long enough for the back scarring to be administered. And that it was that counts against the credibility of the account. Now, we say that that assessment can't stand up when you actually look at the detail of the evidence, which we'll do in a moment. Then conclusion is expressed in paragraph 364 at MS 1021. They say, third line into 364, there is evidence of wide-scale detention of Tamils in Sri Lanka in 2011 and of torture involving burns. However, in our judgment, these facts are not enough, even on the lower standard, to persuade us the appellant was detained in the way that he described or at all, or that he was burned or acquired the scars he has in the manner claimed. In addition to certain discrepancies, his story has too many implausible and inadequately explained aspects. In relation to the medical evidence, we have found that while it assisted in eliminating some possible causes, it left us with only two that were real possibilities: that the appellant was tortured as claimed, that his scarring was SIBP. Of the two real possibilities, we have found on analysis that the former claim does not withstand scrutiny. Certainly we cannot say in his case that the evidence inexorably points to SIBP, but given that we have concluded it is left as the only real possibility that we are not able to discount, taking the evidence as a whole, we are satisfied he has not shown his account is reasonably likely to be true. So, at the heart of this is a finding which is necessary, given the lower standard of proof in this case, that my client's claim does not withstand scrutiny. That's the crucial finding. We say, when you look at the medical evidence, that is simply not supported by any evidential base. None of the doctors thought that. It wasn't put to any of the doctors, even by the tribunal. And as it were, as an add-on, when the tribunal discuss all of this, say in 344, last sentence of 344, able to remain unconscious despite several repeated inflictions of burn scarring, which was an unlikely hypothesis. That, with respect, is not good enough on a Canon Quran basis. The test isn't, is it an unlikely hypothesis? The test is much more, can you discount it? Which is precisely what the tribunal themselves do when they come to express their conclusions in 364. So, in our printed case, if I can just ask the court to pick that up again, it's in Core Volume 1. And we set out, for the purpose, I just ask the court to look at the headings, page 802, MS 802. We have divided up the examination for the purposes of the printed case with an examination of the evidence which goes to whether unconsciousness was necessary in order to explain the shape of the scars. Then over the page at 804, MS 804, evidence as to whether unconsciousness could be maintained without anaesthetic. And finally, Sorry, the final point is the scope of medical expertise. It's the point we've covered in our written submissions.
Just about 22.
Yeah. Yeah. And there's a heading, if your lordships, if the court looks at MS 814, take court through the case law on the role of medical reports in cases such as this, which includes SA Somalia, paragraph 46. So, now it's necessary to actually look at the detail of the medical evidence. And if I can start by looking at the report of Professor Lingham, you will find that in core volume 2, MS 1399, and at MS 1400, page 518 of the core volume, he says, halfway down the page, I confirm I saw the patient injuries as described below, interviewed and examined the patient. Then last sentence, I've taken photographs. We don't have those photographs. The best we've got are the ones that I handed in this morning. Then he gives...
When did he see the patient?
Well, shortly after his arrival in the UK, can I just... 6th of May 2011, I'm told.
Yes, it says so on page 1398, yes.
So what have we got at 1408, Mr. Drabble?
Oh, well, those are his photographs. So, yes, Your Lordship, it's a pertinent question. That's the best quality photograph
I see,
that we've got.
yes.
Yes, I should have said that. I have
Very well.
understood that at some stage. What we haven't got is any photographs that would of sufficient quality to help us with this particular issue, the issue of the shape of the scars. So 1401, page 519 of the volume, he recounts my client's account to him. Then 1402, page 520, describes the scars, which have slightly different numeration from the ones that Zapato Bravo, except for one which I've taken the court already. And then at the top of the page, next door, page 1403 and MS numbers 521, he says, the appearance of the scars indicates that the burning was caused by heated rods rather than wires, as described by the patient. In Tamil, the word can mean both metal wires and metal rods. The patient was in agony, and so he was unable to see precisely the events taking place, unable to describe the precise material used or its thickness. The patient did feel heat and told me that he was in agony each time the beating and burning took place. The patient describes pain from the burning as severe, and that he fainted as a result. According to the patient, all the injuries from the burning took place on one day. So that's an account which is essentially the same as that recorded, as we will see, by Dr. Adili and Dr. Zabate Bravo, burnt, and my client faints as a result. And then the last full paragraph on MS 1403, all the scars are hyperpigmented, and this is due to the healing process when melanocytes migrate to repair the skin. It is the melanocytes which gives the dark coloration. Some scars are darker and also supports the causation due to burning. This finding of marked hyperpigmentation in the scars is therefore highly consistent with the history of beating with metal rods. Burning causes damage to the melanocytes, causing hyperpigmentation, which are clearly seen in each of the scars. And then over the page, MS 1404, page 522. Top of the page relevant. All these scars are similar in appearance, and therefore one would come to the conclusion they are all caused at nearly the same time and by the same mechanism. Findings, therefore, are highly consistent with the history provided by the patient, that all these scars were due to burn by heated metal rods. The scars are very typical burn injury scars. So, actually, despite what the tribunal say about whether Dr. Lingham Professor Lingham thought the account was consistent or highly consistent, at this point in the report he's certainly saying the findings are highly consistent with the history provided by the patient. Now, highly consistent doesn't exclude other causes, doesn't exclude one particular other cause, namely SIBP. But it is an account, it is accepting that the account is highly consistent. And then opinion is on page 523 of the core volume MS 1405. I assessed the scars and injuries in detail. I've given the description of the scars, causation and consistency findings. I fully understand that findings of fact are for a tribunal and considered the scarring and its age inconsistently exclusively from a clinical standpoint after considering the injury as provided to me by the patient. And then the conclusion, top of the page, I have concluded that the scars and other injuries I saw are consistent with the history provided by the patient.
So Dr. Lingham thought all of the scars were inflicted in the same way? Yes.
All the scars are inflicted in the same way, and I mean, insofar as he can say anything about this, on the same occasion. Plainly, that's just common sense.
I beg your pardon. When I say in the same way, I mean when the patient was in the same condition, when the individual was in the same condition.
I think the honest answer that I give to that is that we can't tell. I don't think he's actually addressing that issue. If you look at the end of the first full paragraph on 1403, 521, it says the patient did feel heat, and he told me that he was in agony each time the butchering and burning took place, describes pain from the burning as severe, and that he fainted as a result. Now, it is silent as to whether some of the burns could have taken place after the faint.
Yeah.
It doesn't, frankly, it just doesn't address it one way or the other, that particular issue. But he's certainly not saying, I can tell by looking at these scars that my client's account, which is that he felt the burning, is clinically implausible. He's certainly not saying that. And that's the critical issue. It's not the length of time it takes to inflict the scars. Was my client conscious for part of the time that the burns were inflicted? Now, no oral evidence from Professor Lingham, so that that's the totality of his evidence. Dr. Arnold gives a written report which starts at MS 1357. And I think I can at the foot of page 1361, MS 1361, page 479, he summarises some of contents of paragraph 228 of the Istanbul Protocol. It's out what you're required by the protocol to record, which we'll look at in due course. And then paragraphs 10 to 12 states, may therefore be germane to consider whether any of the above characteristics could assist in the proposed differentiation between voluntary or involuntary branding with hot metal. Physical characteristics of branding scars as seen by medical rapporteurs depend primarily on the rapid total delivery of thermal energy to the affected area. This is a product of the temperature and thermal capacity of the metal object, the duration and precision of contact, and the pressure with which it was applied. If the burns are inflicted by a third party at the subject's voluntary request and performed in an attempt to support a false claim of torture, it would be necessary for the subject to hold still for the duration of each episode of burning. Otherwise, the edges would tend to blur as the involuntary withdrawal reflex caused them to move relative to the injurious object, as Dr. Adili has pointed out. We'll go to what precisely Dr. Adili has pointed out in a bit. Please see further discussion below. There is no other physical characteristic that could assist in the differentiation demanded by the judge. That's the judge in the first tier tribunal. Then he goes on, paragraph 18, CV 482, MS 1364, says, could other medical facts help a medical examiner to reach a clearer assessment which is likely to be more helpful to the courts? It may be pertinent to consider clinically the circumstances required to permit self-infliction of branding scars by proxy. The known facts are wounding of this kind is extremely painful. Pain causes a powerful and involuntary withdrawal reflex, which would result in blurring and irregularities of the outline of the resulting scar, unless the subject is restrained or anaesthetized. The subject is not likely to remain silent unless gagged or anaesthetized. And then he goes on to speculate about what you would need in order to inflict scars for this fault by SIBP in terms of medical facilities. And then at 25 and 26, just says, I am not aware of any evidence other than allegations in a single letter from the Foreign Commonwealth Office in Colombo, subsequently withdrawn, to substantiate the existence of SIBP on the infrastructure or the infrastructure required to inflict it. I've been working in the field for 9 years and well connected in the medical community working with victims of torture, including therapists. I've never heard of any such institution nor ever seen any hint of a reliable report of one. And then he says, well, if there is some evidence, we'll have to change our approach. So the word, just stopping at the report, it is not Dr. Arnold's report that my client needed to be anaesthetised throughout the whole process. The words is actually used. It will be necessary for the subject to hold still for the duration of each episode of burning, and then there's a reference on to Dr. Edili, and we'll come to that in just a moment. Now, at this point, it would be possible to look at the transcript that would show whether that evidence in any way changed during the course of the oral evidence. So that's my invitation, is that we do that.
You'd like us to do that now?
Yes.
Yes. Well, possibly I better ask Mr. Sheldon what he says about that. You can't say it's not admissible, can you, Mr. Sheldon?
I don't.
It's obviously admissible.
I don't, my lady. I don't take a technical objection as to admissibility. I do, though, make a submission as to relevance. This appeal was, as you will have seen, run throughout the Court of Appeal proceedings without any reference to this material, despite there having been 2 years between the upper tribunal decision and the Court of Appeal, including an adjournment of a year for the appellant to further prepare their case. And at no stage was any attempt made to refer to these transcripts. I note your practice direction at 5.1.4 that says that transcripts of the proceedings below should only be included in the appendix if they are essential to the legal argument. And in my submission, these transcripts cannot bear directly upon whether or not the Court of Appeal made any material errors of law in their determination, given that they were not relied upon before them. That said, my lady, I repeat, I do not take an objection on principle, and I do not say that the court is not entitled to look at this material if it considers it would be helpful to do so.
Mr. Sheldon, 3 times in the Court of Appeal, Lord Justice Sales said, well, there's a complaint here about inconsistency between evidence and conclusion of the upper tribunal, but we don't know what's in the transcripts. So they use that as a reason for putting to one side the criticisms. In those circumstances, is it difficult for you to object to this?
Well, my lord, it is difficult. I accept that. But and perhaps I can leave it there.
Yes.
Definitely.
We have to have them.
Yeah, I mean, can I just say one word about that? We didn't prepare for the Court of Appeal with the transcripts. We did it on the basis that we looked at the written material by the tribunal itself, summarising the arguments, with the result that Lord Justice Elias came to. That was our submission. We were met by the answer that's just been expressed, but well, there might be something else in the transcripts. Those on my side of the divide, as it were, today, would not want to be in a situation where it felt obliged to produce a transcript every time a point of detail about the reasoning of a tribunal was being made. It's a fairly onerous task. But there we are. Having said all of that, the thing to do is to look at the transcripts.
And we will find them.
And you will find them in the bundle of supplementary materials. And MS, I think there are separate memory stick numbers for the supplementary bundle. So we're looking in Dr. Arnold. We're looking at MS 370.
370.
It starts at 370. I think the relevant passages. (374)
370 is his examination in chief.
That's where his evidence as a whole starts in the transcript. There's a passage at 374, line 7, line 7 through to 375, line 6.
Do you want us to read that?
Yes. I'm fine with that. And there's another passage, but I'll come back with just a short comment about this. Another passage headed cross-examination by Mr. Duffy, who is the Home Office presenting officer, MS 380, it's line 19, through to 383, line 17, which again I would invite the court to read, comes back at the end of the day to the position which is recorded in the tribunal's determination and on which I relied. The question and answer at 383 lines 15 to 17 is, so it's fair to say that really the only thing you can tell from the scars is KV was burned with a hot metal implement, probably a metal rod of such. That essentially is the burden of my statement to the court. And this court will recall the tribunal recording evidence from Dr. Arnold to the effect that he couldn't tell from looking at the scars whether or not it was torture. The whole passage is relevant. And I think it's do my best to be fair about this. The first passage I've taken the court to, which is the one at MS 374, internal page 29 of the transcript, starts with Dr. Arnold thinking about whether the level of consciousness would be relevant. I think that's a fair summary of what he's saying at 374:19 through to 4. The second passage, starting at 380, MS 380, internal page 35, repeats material that is in Dr. Arnold's expert report, round about transcript page 36, MS 381, line 16 through to 19, about how important the temperature, the thermal energy imparted by the rod will be to this issue, and ends up by saying, I can't tell from looking at the scars whether there was torture. Yep. Just taking one step back, if I forgive this, because Mr. Toll points out that at page 374, internal 29 of the transcript, there's an exchange in which Dr. Arnold plainly accepts as plausible the possibility that severe pain could render you unconscious, and that after that there will be no propensity to move possible to create entirely symmetrical or self-simulated scars without the type of blurring at the edges which might otherwise be seen. So going back to my two issues, do you need to be unconscious for the scars? Is it unlikely you would stay unconscious having reacted to the first burn? Well, there's nothing in that passage which suggests that Dr. Arnold thinks it's clinically implausible that you would stay unconscious for long enough for the later burns to be applied.
Well, he's not being asked about that, is he?
I agree with that. I mean, in a way, this is all a negative. I mean, in the tribunal, positively assert there is a consensus about the two issues. When that is put to the Court of Appeal, the majority in the Court of Appeal say, well, hang on, there might well have been. Let's look at the transcripts. Or, sorry, you can't look at the transcripts. But you don't get from, what you get from this is what the tribunal did indeed record, which is Dr. Arnold saying, I can't tell from looking at the scars what the answer to these questions is. That's recorded. That was the foundation of the submission to the Court of Appeal. Rejected by the Court of Appeal on the basis that one couldn't rely on the upper tribunal record because we haven't produced the transcript. So the next source of medical evidence is Dr. Zabato Bravo. And his report, the court will find his report in volume 2 of the core volume at page 489 of volume 2, MS 1371. Now, my basic submission is that this is a very carefully recorded report. And it answers first an issue about the causation of the scars, in other words, what caused the scars, to which the answer was examination of the scars is diagnostic of the fact they are caused by a heated metal rod. Then addresses an issue of whether the scars are all identical, and if they're not identical, what the difference says about the credibility of my client's account of the sequence of events, and comes to the conclusion that although all the scars are caused by the heated metal rod, which their appearance is diagnostic, they are not identical when it comes to examining my client's account of the sequence of events.
Was any issue ever taken as to this particular clinician's expertise? Because he's a psychiatrist, isn't he?
Yes, he is a psychiatrist. The tribunal raised that issue. Lord Justice Sales also raised that issue. Let me just find the paragraph I'm thinking of in Lord Justice Sales. He has experience of,
Well, if we look at page 1372, he deals with some of his prior experience.
Yep.
Maybe elsewhere, but it's training and clinical experience in various surgical specialities, including general surgery and accident and emergency surgery, trained by the Helen Bamber Foundation, the assessment of the physical and psychological sequelae of torture and ill treatment in accordance with the Istanbul Protocol.
Yes.
Etc. So
the passage I was thinking of is in Lord Justice Sales' judgment, MS 894, it's paragraph 21.2.
I'm so sorry, I missed the page, the MS number.
MS 894.
Thank you.
29.2. And it's really just the first sentence, but that's essentially saying what Lady Hale has just summarised from the CV.
Yeah.
I think I'm entitled to say that the tribunal certainly didn't reject or question his competence to make the observations that he was making.
Yes.
They simply thought there were tensions in them, which, my submission, don't exist. So if we go back to his report, MS 1374, Core Volume 2, page 492, paragraph 9, says at a certain moment when my client was kneeling in front of the officer conducting the interrogation and his arms were held from behind by a soldier, another person came from behind and put his hands around his head. Immediately afterwards, he felt an intense surge of heat coming from behind on the right side of his head. He instinctively turned his head towards the source of the heat as much as he was able, given the restricted movements of his head, and was able to see for an instant the glowing end of an iron rod. He then felt an intense pain, gave a scream, and fell forwards. Does not remember anything else, and believes that at that time he lost consciousness. Next thing he remembers is waking up with excruciating pains on his right shoulder and his back, in the same place as before with the same interrogator, and had the sensation that a couple of hours had elapsed, but he cannot be sure. And then there's an account of what happened in the remainder of the episode. And then there's a passage, important passage, MS 1375, CV 493, paragraphs 15 through to 24 are describing the scars using the numbering And your Lady and my Lords will see that he describes S1 through to S5 ending each description with a statement that my client believed the scar was caused by the application of a hot metal rod during a period of unconsciousness. This is a text for S1. As explained elsewhere, this is an inference on my client's part as he was unconscious at the time of the burning. Then a formula rather similar to that is used for S2, S3, S4, S5. Then we get to S6 and S7, which are the arm scars. Second half of S6 says this area, that's the shape of the parallelogram, this area is sprinkled with small marks that are lighter in colour compared with the predominant hyperpigmented background. My client attributes this scar to the application of the red-hot end of a metal rod that he saw and felt being applied by soldiers in August 2009 during a period of detention. And then a similar point about S7, a similar conclusion. So the report continues by setting out the Istanbul Protocol, categorizations of consistency and so on. And then says, under the heading Interpretation of the Scars, MS 1379, page 497, following comments on the scars are best understood by looking at the scar diagrams in conjunction with the text below.
I'm very sorry, I've lost contact with your MS.
Sorry, MS 1379.
Yeah.
Towards the foot of the page, heading Interpretation
Yes,
of Scars.
thank you. Got it.
And 37 is where he does say that the scars are all similar, which is the source of the confusion in the Court of Appeal, and a rather torrid hour or so trying to explain what Zapato Bravo meant. All these scars present similar characteristics in colour, shape, and precise delimitation. The colour is the same in all of these scars, characterised by hyperpigmentation, which is intense and long-lasting, suggesting the initial burns were deep dermal burns. The long and narrow shape of each of the scars and the precise edges of these marks suggest that the hot object carrying the original burns was solid, for example, metal or glass, narrow and relatively long. And then he discusses S6, comes to the conclusion, last 3 lines of paragraph 38, can be concluded that S6 was caused by a more severe burn than all of the others, in spite of its comparatively smaller dimensions. And then 39 rules out self-infliction. At that point, he's considering what object caused the scars. Answer, hot metal rod. Then he, under the heading Possible Causes of the Scars, CV 499 MS 1381, he records questioning my client to try to identify the size and shape of what caused the burns. 47, very foot of the page, 499, the characteristics that I described for the lesions are unequivocal of scars left by burns. In fact, there are no skin diseases that would produce this pattern of scars, do not correspond to tattoos, etc. And so he comes to the conclusion the hyperpigmented marks S1 to S7 are diagnostic of specific burns caused by a hot solid object. So looking at what caused them, what sort of object caused them, only one answer to that. They are diagnostic of specific burns caused by a hot solid object. Then he goes on to address the issue of whether these burns could have been produced accidentally. Comes to the conclusion that they couldn't. And then there's a heading, could these burns have been produced by a 500 times 25 millimetre hot-threaded rod in the way reported by my client? And he further describes the scars. 55 has a comment. S1 and S2. Ladies and my lords can see. He's saying that there may have been 2 rather than 4 scars. And then crucial passage from 57 through to 63. Ask the court to read. And the heart of the point is really 60 and 61. So having found that all the scars were caused by burning with a hot metal object, there's an unequivocal statement at the start of 60, the scars in the right deltoid area are different to the scars on the back. They're caused by heated rod. The branding was not perfect. And it gives the reasons. Apparent inconsistency explained if my client's report that he was conscious at the time is accepted. And the conclusion is at the end of paragraph 63, as to the possibility they were produced by an instrument, that's talking of the scars as a whole now, possibility they were produced by the instrument described by my client and in the way depicted by him, I should state that my findings not only do not contradict his history, but they are highly consistent with it. So if we move from that to the transcript, so this is in the supplementary bundle at MS 330. And this is in passage, there's a heading on 329, evidence of Dr. Zapato Bravo. Yeah. And some questions from Judge Story. Have a question and answer at 330 line 7 through to line 24, 330 line 24. Goes primarily to the issue of whether it was unlikely that my client would lose consciousness for long enough for the scars on his back to be inflicted. Remember that the upper tribunal's finding was that that was clinically implausible.
Well, he says a clear possible medical effect.
Yes. There's a complication of the 10 minutes. I'll show the court the genesis of the 10 minutes in a moment, but that's the only complication in this submission. He's plainly contemplating that it's not only clinically plausible, but my client's account that he did lose consciousness and was then burnt on his back is highly consistent with the appearance of the scars.
And he was the only person who gave the 10-minute estimate,
Yes,
wasn't he?
I'll show you, your ladyship, the source of the 10 minutes. It's not very rigorous evidence, let's put it like that. There are no submissions by the Home Office about 10 minutes.
No, the point that I was really making was that he was the one who gave the estimate.
Oh, yes.
And he's giving this evidence, no doubt, in the light of what he'd been thinking.
Yes.
He's saying unconscious for long enough.
Yes. Yeah, I mean, you can take that either way. Your ladyship's entirely right. He's certainly saying, when we've seen all of this evidence, I think a fair summary is he's saying, I don't know how long he was unconscious for. I do accept it's possible he lost consciousness, and it's speculation about how long it would have taken to inflict the further injuries. That's what he's saying.
Mr. Drabble, could you help on page 314? So when we read it, we understand who's giving the evidence. Line 8, connection resumed.
Yes.
The clerk, Dr. Shipley. Who's Dr. Shipley?
Mr. Toll thinks that's a mistake for Judge Story. But we don't. I can't give any other answer. I don't know. I don't otherwise know it, Mr.
Who's giving the answers?
Dr. Sabato Bravo on a Skype connection from...
He was in Chile, wasn't he?
He was in Chile, South America, I was going to say. He was in Chile. And there was quite a lot of difficulty about getting the connection to stack up. They had to move upstairs in Field House, I think it was.
So, Judge Story says, line 12, can I just ask you the question I began a moment ago? You say in your report, most likely reason why the appellant fell unconscious was because of S6.
Yes.
Can you hear me? I can hear you now. The judge says, I'm asking you a question. Now, 21, am I right, you say the most likely scenario was that he was rendered unconscious by the infliction of the burn, which you identify as S6. And then, in effect, he says, yes, that is what
Yes,
he
absolutely.
said. Is that right?
That is completely right, yes.
Very well.
Yes, I mean, it goes back to the exchange we had earlier in the morning. At no point is even the tribunal putting to Dr. Zapato Bravo, that's just not credible or that's clinically implausible. They are attempting to elucidate what the thrust of his evidence was. And as your lordship puts to me, his evidence was the most likely cause was him losing consciousness because of S6.
So this business of being unconscious throughout, arms and back, didn't come from Zapato Bravo?
No. I won't go back to the passage, but in the key passage in the upper tribunal, they say that they rely on Zapato Bravo and Adili for the consensus about a need for unconsciousness throughout. Well, we'll look at Adili possibly after lunch, but it certainly doesn't come from Adili either. Now, so we have looked already at 330. If the court will then go to 335,
Mr. Drabble, it's 1 o'clock, so
yes.
Is this a convenient moment?
Yes, perhaps I'll just to tell your ladyship the reference, and then we can pick it up straight away.
Yeah.
Yep. The passage that I was going to take you to was MS 335, line 18, transcript page 59, line 18. And the passage goes on, in fact, to MS 337, line 25. And the 10 minutes is at 336, 24 through to 27. Sorry, 29. The answer at 29 is important.
Very
Your
well.
client having said, correct me if I'm wrong, from the earliest possible moment, namely in the initial interview, I don't know how long I was unconscious for.
Yes.
I was unconscious. Is that right?
Absolutely right. I mean, I have the straightforward point that my client's account in the interview is consistent with the account to all the doctors, and none of the doctors said this account is clinically implausible. In fact, the opposite.
I was just going to assist with the question that Lord Wilson asked about the skeleton arguments below. In the material, there is the skeleton submissions that were made on behalf of Helen Bamber Foundation. They are the only substantive submissions on the question of the role of the expert. And, my lord, they are in supplementary bundle MS 59, in particular paragraphs 10 to 20, which is MS 62, 67, or page 60 to 66.
Thank you.
Thank you, Ms. Harrison.
But, Ms. Harrison, the other part of my inquiry was, it is said by Mr. Drabble that the upper tribunal got it right about
Yes.
the role of the expert. what was the Secretary of State saying to the Court of Appeal? That's why I wanted to see
Yes.
that skeleton argument. Was the Secretary of State saying, no, that is quite wrong, it's far too wide?
It doesn't do that at all. I think it's fair to say that the Secretary of State made no substantive submissions on the law. I was the only advocate who did in writing, and there were some short submissions in the oral hearing. I think it's right to record that Mr. Sheldon said my document was impressive and didn't object to it at all. He may take a different view now, and the court may take a different view, but that was the position below.
Thank you.
Thank you. I will adjourn now and resume the hearing at 2:00.